The court instructs you that the mere fact that the plaintiff received a fatal injury while working for the defendant does not entitle the plaintiff to recover a verdict in this case. The plaintiff is not entitled to recover a verdict unless she proves by a preponderance of the evidence, and by that is meant a greater weight of the evidence, the following propositions. First, the plaintiff must prove by a preponderance of the evidence that she was at the time and immediately before she received the injury in the exercise of reasonable and ordinary care for her own safety, and that she could not have prevented the injury to herself by the exercise of such reasonable and ordinary care. If she could have prevented said injury, then she was bound to do so, and if you find from the evidence that she failed to do so, and such failure contributed in any way to the happenings of the injury, the plaintiff is not entitled to recover in this suit. Second, the plaintiff must also prove by the greater weight of the evidence that the top of the machine in question was in a dangerous and unsafe condition as charged in some one count of the declaration, and that the injury was caused by such dangerous and unsafe condition and was not caused by any want of ordinary care on the part of the plaintiff. Third, the plaintiff must also prove by the greater weight of the evidence that Jones did not himself know of such unsafe and dangerous condition, and that he could not have known of it by the exercise of reasonable care. If you find from the evidence in this case that the plaintiff has failed to prove by the greater weight of the evidence all or any of the foregoing propositions contained in this instruction, which you have been instructed, she is required to prove by the preponderance of the evidence, then you are instructed that she is not entitled to recover in this suit and your verdict must be for the defendant. You are instructed that there is no duty upon an employer to warn and instruct an employee as to dangers which are open, obvious and patent to persons of ordinary intelligence, and one who attempts to do work which exposes him to obvious and known dangers assumes the risk of such dangers. If you believe from the evidence that the condition of the machine in question was open and obvious to the plaintiff, then you are instructed that it was not the duty of the defendant to instruct him that such condition was dangerous, and if you further believe that the plaintiff was injured as the result of such open and obvious condition, then the plaintiff cannot recover and your verdict must be for the defendant. You are instructed that the plaintiff has alleged in this case that Jones sustained fatal injuries by reason of the fact that the defendant negligently allowed a certain machine to remain open and uncovered and allowed the planks and surroundings to be greasy, slippery and not sufficiently lighted. You are instructed that before the plaintiff can recover, he must prove by the greater weight of the evidence. First, that at the time of the accident, the place in question was not a reasonably safe place to do the work being performed by the plaintiff. Second, that Jones did not know that the conditions were dangerous and unsafe. Third, that Jones did not have equal means with the defendant to know of the facts concerning the condition of the top of the machine and the light surrounding it, and of the dangers arising from such conditions. Fourth, that the injury to Jones was sustained by reason of dangerous conditions. If you believe from the evidence that the plaintiff has failed to prove any of these four propositions by the greater weight of the evidence, or if you find that his injury was sustained by any other fact than that the top of the machine was not a reasonably safe place upon which to work, then you are instructed that the plaintiff cannot recover and your verdict must be for the defendant. You are instructed that the mere fact that Jones was employed by the defendant company, that he was injured while in its employment, does not in law raise any presumption in favor of the plaintiff's right to recover in this case, neither does the fact that the plaintiff has brought the suit, which has been tried before, indicate that the plaintiff has any right to recover.